Medical records. What could be more important in a personal injury case than medical records? And in considering some of the factors I'd like to bring to your attention in today's blog, I thought back to how when I started in personal injury law at a defense firm in the 1980s, my boss would frequently go to the Middlesex courthouse to read medical records of various clients who had cases against my firm. He would have them sent to the clerk's office of the local superior courts or wherever we had a case. And my conclusion was, gee, when you file a personal injury suit, you are opening yourself up. Your whole medical situation, sometimes even before the accident, often even before the accident, is open for scrutiny. And the feeling is, of course, we all safeguard the privilege of medical records and privacy, but when you put a case in suit or you make a claim, you have, in effect, waived the privilege. Well, those are some issues that are of concern. But recently I had a case where I was confronted happily, so perhaps I shouldn't use the word confronted, with medical records that supported my client's injury, not a surprise, but also his whole narration of how his injury had happened was supported in the medical records. And that was a good thing, a great thing, especially because this client went to the hospital immediately after his accident and obviously had not retained the services of a lawyer, and therefore he had not had any chance to really be mindful of legal considerations. And secondly, I got this case 14 months after the gentleman was injured. It had been with another lawyer, so I really had a lot of reconstructing to do, and the medical records helped me on that. The first thing I noticed, and obviously I will never reveal, nor would you expect me to reveal the client's name, but in the medical records, it describes extreme or extremity pain, meaning legs, arms, after a mechanical fall. You'll see that term mechanical quite often used in medical records, and it talks specifically of his complaint's shoulder. And he had had rotator cuff surgery months later, so this entry occurring on the day of his accident was a very, very important entry. And as often happens with medical records, what's there once gets repeated and repeated in successive medical encounters. And indeed it did here. Now they took x-rays and the gentleman did not have an acute fracture. Acute means in terms of time, it was not something that there was right then and there showing a fracture or a recent fracture. But the fact that they took x-rays did cause even more support for the contention that he had injured this, this extremity, which I had referred to earlier, because it was shoulder and upper arm pain. And oftentimes, you don't expect a fracture to show up. You would expect that there would be damage that would be revealed only upon a CAT scan or an MRI, which is looking at more than the condition of the bones and whether the bones were fractured. So because it said mechanical fall and because it corroborated his injuries, another way of expressing it is just confirmed what he had said, we got great support from the medical records, and I was so appreciative because, again, I didn't get the case till 14 months later. I will say that the records can giveth and they can taketh. There can be the good in the records and the bad. It says under assessment and plan for this gentleman, fall, likely mechanical fall, slippery ice surface. That was very nice. But the next sentence is a bit disconcerting because it said patient gait and balance likely compromised by long-standing knee pain. So you can well imagine how an insurance company could use that to try to say that the man's walking had been compromised at the time he fell. We were very successful in the case, so that point didn't hurt us. But I do want to tell you again that the medical records can be very good or they can be bad. There is another reference that I found interesting and I would like to bring to your attention. It says, patient states that he fell when he slipped on ice concealed by a puddle in front of his residence. That was exactly what the client had said all along. So you can see here he's saying it in the hospital before a lawyer, as I said, and at the very onset of the accident he's saying it. When he was unable to get up, he required the assistance of 2 people to stand, it says. But again, the bad happens. They note a separate fall 2 years ago when he lost his balance. Now, that in and of itself could not be a factor. It may not be a factor, and as I say, it wasn't in this case, but anything in a fall accident reflecting on the person's inability to walk normally can be an issue. In this particular case, the records were, on the whole, extremely helpful and a very nice source in which to help me to build a case 14 months after the fact when the client came to me. Thank you.